Hello, and welcome to Cloaker's Education Foundation, where we provide quality content for amazing teachers and students. If you're joining us from our previous video on the Constitution, welcome back. If this is your first time, we're glad you're here. This is our U.S. government series, and this lesson is on the Bill of Rights. Now, before we begin, feel free to check out the link in the description below for a set of free guided notes that go along with this lesson. Now, let's dive in. The First Amendment. Now, the First Amendment encompasses many things such as free speech, the freedom of religion, and the freedom of press. It states Congress shall make no laws respecting an establishment of religion or prohibiting the free exercise thereof, or abridge the freedom of speech or press, or the right of the people to peacefully assemble and to petition the government for a redress of grievances. So let's clarify what this means. The free exercise of religion. What does it mean to exercise your religion? That means belief, that means prayer and worship, that may mean opposition to a government policy such as military service or school requirements or vaccination. The state cannot force you to exercise or participate in a religion. I know what you're thinking, Mr. Cloaker. The government can't force me to practice a religion. Correct. They cannot force you to pray. They cannot force you to go to church or mass or temple to participate in a religious service. That's your right as an individual. There are two prominent American businesses, Chick-fil-A and Hobby Lobby. They are both famously closed on Sunday. Everyone knows the dilemma of where do you want to eat at? Oh, Chick-fil-A? Oh, it's Sunday. You can't. They're closed. Now, these Sunday closures in honor of the Sabbath allow the staff an opportunity to engage in those religious activities, to spend time with their family. It sets them apart from the rest of the competitors that are open 7 days a week, but it's their discipline to the faith. Now, they cannot force you to go to church on Sunday. If you work at Chick-fil-A and you don't go to church, they can't force you to do it. The government cannot force you to do it. Hobby Lobby cannot force you to do it, even if you're employed with one of those organizations. The First Amendment clearly states that there is no respecting the establishment of religion. Now, this means different things depending on who you asked. The strict separation theory says there should be no aid of any kind. There should be a strict wall of separation between government and religion. There's a theory of government neutrality where the government must neither help nor hinder religion, but it's going to interact with it. It must remain neutral. And the theory of government accommodation. Some accommodation is needed because we are a religious people, and we will make accommodations for those people that practice certain religious faiths. Now, there have been court cases that come up with the free exercise of religion. So, example, West Virginia versus Barnett in 1943. At the height of World War II, West Virginia had a law mandating a flag salute in the Pledge of Allegiance, and students that were Jehovah's Witnesses refused. Now, no business nor government can force you into religion, and their belief system that stated that they could not swear allegiance to a flag or any other symbol of authority that was not God. And so the court agreed with Jehovah's Witnesses and said, you cannot force them to violate their religious beliefs, much like you cannot force someone to practice a religious belief. And the court stated it did not just apply to Jehovah's Witnesses. And so even today, there are people who refuse to stand up and salute the flag in the Pledge of Allegiance, and that is your right to do so. They cannot force you to stand up and salute the flag. Another court case that has come up because of the First Amendment is the City of Boerne, Texas versus Flores in 1997. So the City of Boerne denied the Catholic Church a permit to construct a building addition. The city said that the church was located within a historical district and the addition would violate their zoning laws. the church claimed a violation of the RFRA, the Religious Freedom Restoration Act, which was supposed to say that the state would not burden the churches or religious institutions with excessive rules and regulations. Bernie stated that its zoning laws should apply to the church just as they apply to everyone. The Supreme Court held that the Religious Freedom Restoration Act was unconstitutional as it applied to the state, and that Congress had exceeded its authority with the law, and that Bernie, the city of Bernie, did not need to give any special treatment to a religious organization when it came time for zoning. Now, other court cases have, of course, come up because of this. Religion is such a broad topic, it's bound to happen. One of them being Wallace versus Jaffrey. Can the government mandate a moment of silence in public schools that is to be devoted to prayer and meditation? Now, in this court case, the Supreme Court ruled that the Alabama law was unconstitutional because it specifically directed students to pray or meditate during the moment of silence. However, they did clarify that a school district can say, and now for a moment of silence, that's completely allowed. They cannot mandate that you pray or meditate, but they can mandate a moment of silence. And in many schools and in the state of Texas, if one is disruptive or loud during that moment of silence, that could cause a referral because you are interfering with a student's ability to pray if they choose to do that, or interfere with their ability to meditate if they choose to do that. And of course, that will vary from school to school and how that's enforced, but that is one of the policies here in Texas. Now, the First Amendment continues on. Congress shall make no law that abridges the freedom of speech, press, assembly, petition of grievances against the government, but Congress does indeed limit your freedom of speech. And you might be thinking, Mr. Cloaker, that's wrong. Let me explain this to you. So the theories of free speech, John Milton stated that a restriction on an open press are wrong because they were used by tyrants who were not deserving of allegiance or respect. They inhibited the development of individual character and potential. They were ultimately ineffective because suppressed ideas still become known, and they discouraged learning and the search for the truth. In other words, John Milton says, I can say whatever I want because the First Amendment says I can. This is incorrect. John Stuart Mill comes back and says that speech can be restricted when it infringes on the personal rights of others, and this is what our government stance is on freedom of speech. Censorship is dangerous and wrong. Why? Because censorship, ideas may be true and the majority opinion may be false. Censored opinions may contain some elements of the truth, and even if true, prevailing opinions must periodically be subject to testing to make sure that it remains the truth. Now, what does this mean? How do you censor speech? Free speech does not mean slander. False speech intended to damage one's reputation, or libel, which is very similar to slander, except it is when it is written or published statements. If it's online, it's libel because it is written. And examples of this, you cannot yell fire in a crowded theater, or you cannot say bomb on an airplane because it incites a panic. And then some grandma gets trampled because everyone's running out. You can't reveal government secrets because you're threatening national security. Those are examples where the government can restrict your freedom of speech. Several court cases have come up to challenge the extent of the freedom of speech and the freedom of press. One of them in 1919 was Shinek versus the United States. Congress had passed the Espionage Act during World War I, and the Espionage Act made it illegal to promote insubordination within the armed forces or to interfere with the draft of soldiers. You cannot encourage them to disobey orders, nor could you interfere with the national draft. Shinek and his fellow socialists distributed pamphlets that criticized World War I and urged soldiers not to fight. Now, the Justice Oliver Wendell Holmes wrote the majority opinions, and he stated that this created a clear and present danger. This is the limit to censorship. The doctrine states, whether the words are used in such a nature to create a clear and present danger, they will bring about substantive evils that Congress has the right to prevent. This is how the government can censor you from, again, yelling fire in a crowded theater or bomb on an airplane. It creates a panic and creates a clear and present danger, and Congress has the right to prevent it. The Supreme Court decision was unanimous. All 9 members agreed and upheld the conviction of Schoenecht. Now, Justice Holmes said that speech needs to have 2 things looked at when you are questioning whether it is protected or not. A question of proximity and degree. How close is the speech to creating that immediate evil? And even the most stringent protection of free speech does not protect a man from falsely shouting fire in a crowded theater because it creates a panic. Again, Congress can abridge free speech if that free speech creates a clear and present danger. Now, speech is not just verbal. Speech is also symbolic. We saw this in 1968 when the U.S. versus O'Brien made it to the Supreme Court. This is in the midst of the Vietnam War, and the issue was simple. Can the government require young men to maintain their selective service cards, their draft cards, as a part of a national selective service system? How does the First Amendment protection of speech protect a young man who chooses to burn his draft card to protest the Vietnam War? And the government came out and the Supreme Court stated that the interest in the draft outweighs any First Amendment claim of the individual. And so a soldier burning their draft card is inhibiting protection of the United States, and that government's claim is more important than his individual rights. In 1989, a court case comes up, Texas v. Johnson, and this is on the issue of burning the American flag. Now, it's a very popular form of protest in the modern day, but in 1989, Texas had a law that banned the burning of the American flag because it was the desecration of a sacred and venerated object. Mr. Johnson claimed that it was his First Amendment right to burn the flag as a political protest. Texas said that it was protecting a sacred object. The Supreme Court comes out in a close 5-4 decision stating that burning the American flag is a political or public protest, and that is protected by the First Amendment. It not only struck down the Texas law preventing the burning of the American flag, it struck down a federal law prohibiting the burning of the flag. Freedom of speech is not just what you say, it is also how you act and how you express yourself. Now, some things have come up and issues that have come up that have been struck down and protected under the First Amendment, notably nonviolent sit-ins. That is a protected First Amendment right. Burning the draft card was not protected. Tinker versus Des Moines in the 60s, students wore armbands, black armbands, to protest the Vietnam War. They were expelled by their school district in Iowa. The Supreme Court said no, that is a protected First Amendment right. In the 60s, a student wore a jacket that said F the draft on the back. Now, this is the 60s protesting the war. I'm not censoring that. It said F the draft. Again, not censorship for YouTube. That's quite literally what it said. And the Supreme Court said no, he is making a political statement about the draft. I don't think you could get away with that now because the draft is not instituted. It used to be taboo in American society to wear the U.S. flag as items. So wearing a American flag shirt or wearing American flag shorts or shoes that have the stars and stripes, that used to be very taboo. And so some states tried to ban that, and they said, no, having the U.S. flag on your pants, that's protected. Having American flag apparel is protected. Flying the flag upside down because you are upset and protesting the state of your government, that is protected. Burning the American flag is protected. Totally nude dancing is not protected. It's called public indecency. Don't do it. You'll get arrested. A student skipped school in Colorado to attend a weed rally shortly before they legalized it, and he had a banner that stated, "Bong hits for Jesus." He was suspended. That was not protected. It had not been legalized yet, and he was not of the age that it was going to be legal for. Don't do it. I'm telling you now, don't do it. Now, I feel like that's a pretty good wrap of our First Amendment, so let's look at our Second Amendment. The Second Amendment states that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Just like that, not many words, but very, very specific. This leads to two interpretations of the Second Amendment. The first is that it means the states have the right to a well-regulated militia, and a 20-year-old kid with an assault weapon has nothing to do with the militia or the security of the free state. The other side states the Constitution very clearly says the right of the people shall not be infringed, in contrast to the militia. It does not say the right of the militia shall not be infringed. Now, why would they say the people's right shall not be infringed? Because the framers of the Constitution, the people who just wrote this, had fought in a war against the tyrannical state militia of the British, and they knew there may be a time when they have to do it again. The Third Amendment states that no soldiers in time of peace shall be quartered in any house without the consent of the owner, nor in a time of war, but in a manner to be prescribed by law. Now, this came about because during the Revolutionary War, King George was putting British troops in the home of the colonists without their consent, and he was forcing the colonists to bear the burden of providing for his soldiers. Shelter, laundry, food, all of that was being paid for and being done by the colonists without their consent. Now, the Fourth Amendment is quite a big one. I love talking about this. The Fourth Amendment states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by an oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, let's talk about that. Now, search warrants, they must describe the place to be searched. 123 Elm Street, that is an address. Storage building F, that is a specific place that you are searching. It must describe the persons or things that are going to be seized. Drugs, weapons. John Smith, a person. It must be prescribed on probable cause, a practical conception. Considerations that things may change, but it has to be quantifiable into percentages, and it must be sworn before a judge. The executive branch and the judicial branch have to come together for a warrant. Now, back in the olden days, this was difficult because if a police wanted to search your house or a item, they had to physically go to the courthouse and talk to the judge and get the judge to sign it. Nowadays, they can fill out a form and send it via email on their phone and have a search warrant within minutes, depending on the time of day. It's much easier to get in this era of technology. Now, what is constitutional without a warrant? So if the police stop you on a street and pat you down on your clothing, that is completely protected without a warrant. All they need is probable cause. Government agents placing listening devices outside of telephone booths because they are public places. And I realize now that in the 21st century, there are not many telephone booths left in public. The police can attach a GPS device to your car and track you for 28 days without a warrant. If they go to 29 days, they need a warrant. But if they get it out on the 28th day, they do not need a warrant for that. Completely legal to do that. If the police stop an automobile for a routine violation, expired tag, turning without signaling, speeding, they can order everyone out of the car and search the vehicle. If the police do a fly over a field, either with a physical plane or a drone, and they see criminal paraphernalia such as marijuana, that is legal. The plants were not visible from the ground due to a 10-foot privacy fence, but if it is in public in a flyover, that is legal evidence. They don't need a warrant to fly over your property. Now, Mr. Cloaker, it clearly said that there could be people on there. I understand. And people are mobile. We have these things called legs, and we can run away and drive away and roll away all the ways we can. There is an exception known as the hot pursuit exception. You probably have seen cops, right? If a fugitive runs from the police to escape a search or to escape a crime, they may go through a home or a private dwelling without stopping to get a warrant, because stopping to get a warrant might delay them and endanger the police or the public. So if Bobby Lee runs and jumps the fence and runs through your house, the police can chase him through your house without a warrant. Now, let's say the police go and search 123 Elm Street and look for John Smith and Bobby Lee. If they are going through and looking and they see criminal paraphernalia that is out in the open and it's immediately apparent what it is, that is considered evidence. They don't need a warrant. They can fly over and see things in your backyard. That is considered plain view, and a plain view exception. It's out in the open. They can use that in court. Now let's talk about consent. Police may ask you to consent to a warrantless search. If you say yes, then they don't need a warrant. Police are not required to tell you that you have the right to refuse a search. Now again, if you are pulled over for a traffic violation and they order you out of the car, they have the authority to do that because of the traffic violation. They don't need a warrant to do that. But if they just show up to your house and ask if they can come in and they don't have a warrant, you can say no. Again, they need to have a warrant, probable cause. Can one person consent for another? Kind of. Let's talk about it. So if the police show up and you're in an apartment and your roommate answers the door, your roommate can consent for them to come in and search if they ask. If you're at a party and a visitor goes and opens up the door, you're in the backyard cooking hamburgers or hot dogs or tofu, whatever you eat, and a friend of yours goes and opens the door and they ask to come in. If the police have no reason to believe that that person doesn't live there, they think that person is a resident, that person can consent to a search. Now, the tricky thing is when the search of a residence is unreasonable when one occupant consents but another who is present refuses. And that was passed in 2006 when Georgia v. Randolph was taken to court. We have the Fifth Amendment. The Fifth Amendment protects people from being held for a crime unless they are properly indicted or accused. Now, this means once you get arrested, the state, the county, the law enforcement has 24 hours to formally press charges and indict you with a crime. Otherwise, they have to let you go after 24 hours. Again, 24 hours they have to accuse you of the crime. This also states that you may not be tried for the same crime twice. That's double jeopardy. This means that if you go and you rob a 7-Eleven and you come back 2 hours later and rob it again, that is two separate crimes. That is two separate punishments. That's not double jeopardy. This would be if you murdered someone and you were put on trial for that murder twice. They only get one attempt at taking you to court. Now, that also says you have the right to not testify against yourself. So you cannot be called to the stand to testify against yourself. That is self-incrimination. You don't have to do that. Now, your lawyer or legal representative may encourage you to take the stand, and they'll ask you questions to, of course, get your side of the story. It also encompasses this thing known as your Miranda rights, which comes out of Miranda v. Arizona. Now, your Miranda rights you've probably seen on cop movies or cop shows. It is 5 statements followed up by 2 questions. You have the right to remain silent. You see this when they get arrested. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided to you. If you decide to answer these questions now without an attorney present, you will still have the right to stop answering at any time until you talk to an attorney. Do you understand the rights that I've just read to you? With these rights in mind, do you wish to speak to me? They may ask you that last question. They might not. Again, it determines on a lot of things like the situation that is going on. And when I say situation that's going on, I mean that if they're in the middle of a shootout and they arrest someone, they are obviously not going to read them their rights at that moment because that is putting them in danger. They're going to resolve and neutralize the situation before they continue. But with that being said, that takes us to our Sixth Amendment. The Sixth Amendment guarantees a speedy trial. Now, what does speedy mean? Speedy means that it is a year. Yes, I said it. They have a year to collect all of the evidence and send you to trial. Now, that's from the day that you are arrested and you have formal charges indicted against you. A year. So if you are arrested for again, robbing the 7-Eleven, we used this earlier, they have a year to gather all the evidence, and unless there's some extreme circumstance that is going to impact everyone, like if a hurricane hits, they might delay it and extend it, but generally it means they have a year. You have the right to an impartial jury, one that doesn't think you're already guilty. This is a huge issue when it comes to celebrities going to court, such as Bill Cosby when he went to court, or Johnny Depp. The impartial jury can't think you're already guilty. And this is a big issue with celebrities when it hits the news because the media wants to run with it and sell it. And so it starts impacting what people think before they get to hear all of the facts in the courtroom. You have the right to confront witnesses. If someone is going to testify against you, you have the right to confront them. And you're allowed to have a lawyer. That ties directly into your Miranda rights. And if you cannot afford one, one will be appointed to you. Now, when it comes to your right of legal representation, people do not realize how important that is until you need one. In this court case, Gideon v. Wainwright, the police arrested Gideon and charged him with breaking and entering with the intent to commit petty larceny, basically breaking into a place to steal. Now, Gideon appeared in court alone as he was too afford a lawyer, and the following conversation happened where the court said, "Mr. Gideon, I am sorry, but I cannot appoint counsel to represent you. Under the laws of the state of Florida, the only time the court can appoint a counsel to represent a defendant is when they are charged with a capital offense. I'm sorry, I'm going to have to deny your request to appoint counsel to defend you in this case." And Gideon says, the Supreme Court states that I am entitled to be represented by counsel. And so his court case got appealed where he could get legal counsel to represent him. Now we have our Seventh Amendment, which states, in suits at common law where the value of controversy shall exceed $20, the right to a trial by jury shall be preserved, and no fact tried by a jury shall otherwise be re-examined in any court of the United States. Now, when this law was first written, $20 was a lot of money. Nowadays, not so much. Now, the right to a trial by jury is very important, and if you are, God forbid, in a position where you have a court case and you have the options to a trial by jury or a trial with just a judge, there are upsides and downsides to both. You may win over a jury of your peers. However, there's generally more court fees associated with that because they have now inconvenienced quite a few people to come in and hear your court case. It is also much more difficult to appeal the decision of a jury as opposed to if it is just a judge. And so it's often easier to have a trial with just a judge. But if you choose to have a trial by jury, those are two things that you need to be aware of. A, there's going to be increased court fees, and B, that if they find you guilty, it is much more difficult to appeal that decision than if there's just a judge. The Eighth Amendment is very simple, pretty straightforward. There's not a lot of controversy around it. The Eighth Amendment guarantees that punishments will be fair and not cruel, and that extraordinary large fines will not be set. So if you steal a Snickers bar from a 7-Eleven, you're not going to have your hand chopped off like you would in certain countries around the world. The Ninth Amendment states that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. In other words, that this list of rights shall not be misconstrued to deny those kept by the people, aka we have a list of rights for you, the individual. However, there are more rights that you have that are not listed on paper, and you have access to those rights as well. And lastly, the 10th Amendment. The powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. So in other words, if it is not explicitly stated in the Constitution, it is left up to the states because it is not the federal government's job. If the states do not have a law, it's generally pushed down to the counties now and then to the people, you, the individual. And so we have a hierarchy of laws, national laws, state laws, your own individual beliefs, personality, and laws. And so the Bill of Rights, the first 10 amendments to the Constitution, why do we have this? Well, it protects the individual and their rights and freedoms from the government. The founding fathers, the framers of the Constitution, they were concerned about what might happen because the British monarchy, the British oppression, all of these rights were in response to the oppressions they suffered underneath the British crown, where they could do things without caring about the rights of the people. That is why we have these Bill of Rights. It is to ensure equality, that we continue to enjoy these blessings of liberty, and this helps everyone in the U.S. enjoy their freedoms and learn from their past mistakes like we do as a country. Thank you, ladies and gentlemen, so much for watching. That concludes our lesson for today. Don't forget to like and subscribe. Check us out on Teachers Pay Teachers, YouTube, and Rumble. Our next lesson on the legislative branch, right there on the screen, is just a click away. I'll see you there.